We have one of our members who did ask to make some comments, Jim Wallace, about the status of his legal actions. And one of them is, I'm very excited about, because one of them is coming forward from some time past. And I think a lot of people may be surprised about it, as well as what is going forward. So I'm going to let Jim take over from here, and he can speak as loud as you need him to.
Okay, if you can't hear me, just let me shout out. There are press releases for both lawsuits that I'm involved in. I'm the sole plaintiff in one, and I'm one of four in the other. And if you think that makes me happy, you're wrong. It doesn't make me happy at all, but it's something that I feel needs to be done. I'd like to ask you, how many people feel that CSTP is facing a real serious crisis here, Jim? One that hasn't been discussed so far today. Okay, that's what Catherine asked me to do, and this is tricky because I'm going to talk about these lawsuits. Everything I'm going to tell you has been is really in the press releases that I made available to you all here today, and they're press releases that were approved by my legal team. We have one hell of a legal team. And I'm needing a little bit in my promised time here. I promise I will get through both of these cases in about 10 minutes, and I'm going to do that by using some script I have. If you want more detail, there is some more detail in these press releases. So anyway, last month I provided a press release and discussed the case Wallace versus et al., which are the four other plaintiffs, versus Sarasota County, that involved the county's removal of CSTP's hotel room density requirements from Sarasota County's land use code, as well as all but immediately approving BOC's two new hotels, one in Miramar and the other one in Old Stickney Point. To be specific, on October 27, 2021, the Board of County Commissioners also approved a new hotel in the CSTP North Village, and then on November 2nd, followed up very quickly with another new hotel, this time on Old Stickney Point Road. That's a really serious hotel, right? I mean, that's going to do an enormous amount of damage to an already terrible intersection to start with on Midnight Pass and Stickney Point. As approved, both hotels would vastly exceed the maximum density requirements of the Sarasota Comprehensive Plan Policy 2.9.1, if you really needed that number, that adopted the CSTP Land Development Code as it existed in 1989. In other words, they invalidated what was in this code approved back in 1989, which established a maximum of 26 rooms per acre. Not only did they do it, by the way, for CSTP, they did it for the whole county at the same time. A number of the plaintiffs are involved in this case. For, as I mentioned, all of the plaintiffs would be adversely affected by the increase in hotel room density and associated increase in pedestrian and vehicular traffic and other issues arising from this high density development. However, and moreover is the right word, the resultant increase in emergency vehicle travel times were never even assessed by the county. I want to tell you, in both of these cases that I'm going to talk about today, absolutely no analysis has been done on the impact on CSTP. I got them on the record on that. Okay, and the meetings with the head lawyer of all of FDOT in front of the whole, my lawyer, my legal team, professional engineers, and the then chairman of the CSTP Chamber of Commerce were all in on that session. So anybody thinks, or if they ever claim, and you hear it, that they did any impact analysis on CSTP, they did not. They absolutely did not. It's a lie.
Jim, you got to talk up.
Okay. A number of plaintiffs are involved. I've said that. At the end of this, one commissioner, before this was approved, this is in the October 27th meeting, one commissioner did get it right. This was Commissioner Nancy Dieter, and she stated before they, in legislative session, changed the ground rules and dumped the density requirement. She said as follows: I cannot be proud of something to be dictated with policy by someone who owns just 1 acre. And that policy is for the entire county. Makes me very uncomfortable, end quote. She went on to say, quote, we should take the time to do this right. As we sit here, it is probably the most important vote you will ever take in your political life. She went on to say, expect court cases. Nancy Dieter was the lone no vote for that change, and she forecast the legal response that was correct. The county's response, this is looking forward, the county's response to our brief is due next Monday, January 10th. Where things go from here with this particular case, I call this case the kill shot case. If we win this case on count number one, it's over. They have to go back to the drawing board. And both hotel approvals are also dead. Okay, everybody needs to understand that. So the significance of this case is if we lose it, we will have a flood of additional new hotels approved on CSP. We want to win this case. Now, in our filing, we have additional counts, so that if we lose on count one, we're not done. Next, I'd like to brief you on the status of our second key legal action. As many of you know, in 2019, the 5-member BOC approved a massive Benderson new project on the mainland project, really out on the corner. It was the 10-year vacant 24-acre northwest corner of Stickney Point and 41. This new development that's currently underway, you can see what's going on Stickney Point, making way for potential light, underway requires a new intersection and stoplight on Stickney Point Road between US 41 and the South Bridge at Avenue B and C. This traffic, think about what I'm saying. This traffic light per FDOT, per their own numbers, will stop east-west traffic dead in its tracks about every 80 seconds. Every 80 seconds. Add that to what you've been seeing going on in Stickney Point. The importance of this second case is that the entire Benderson project was approved contingent upon FDOT approval of the traffic signal. If we win this second case, we stop the traffic light in this all-new intersection and thus stop the Benderson Siesta Promenade project cold as it's currently designed. They'll have to go back to the drawing board. Basically, the only thing they'll be able to do is convert to residential park. Okay, because without that light, they can't get people out. 3 out of 4 flows can get in, but they can't get out. So I'm the sole plaintiff in this case before the Second District Court of Appeals. And I will now cover the highlights from the press release on this particular case. So this is all new information. This press release has come before you today. You're the first to receive it. On December 15th, 2021, my legal team filed an appeal of FDOT's, filed appeal of FDOT's decision to deny a hearing regarding the FDOT permit for a new signalized traffic intersection on Stickney Point Road between the South Drawbridge to CSTP and the 41 intersection. FDOT had previously acknowledged the severe pre-existing traffic safety and operational problems associated with this roadway and the 41 intersection. Problems that, in the FDOT's own words, this was a 2016 memo that went to Paula Wiggins of the Sarasota County planning area. It said this land use planning associated with this intersection required that access type safety concerns and operational limitations of this intersection should be given critical consideration. However, FDOT later totally ignored these facts, their own facts, and instead issued a permit and denied a formal administrative hearing to challenge the permit. The upshot of it is we spent over, no, I shouldn't use the number, a lot of money. And we still haven't gotten to the merit stage of this case. Okay, so we're still working on getting the merit. This FDOT permit approved the creation of this new signalized intersection at Avenue B and C on grounds that being stuck in traffic is insufficient to establish legal standing. That is me being stuck on traffic, right? However, the allegations of our petition established that my interest encompassed far more than just being stuck in traffic. But this case is not just about me, one CSTP resident. This case raises an important issue as to whether, under the Florida Administrative Procedures Act, the uniquely situated residents of Florida's offshore barrier islands, who depend almost exclusively on a single roadway for access to and from their homes and the mainland in order to conduct their daily lives and receive emergency medical services, do in fact have legal standing. Stickney Point Road intersects US 41, a major north-south arterial roadway, as you know. This intersection already frequently has level of service F. This is FDOT. These are FDOT ratings. And F represents near gridlock conditions where every vehicle moves in lockstep with the vehicle in front of it, and traffic frequently comes to a complete stop. Under these conditions, traffic on Stickney Point Road backs up from the Stickney Point Road US 41 intersection on the mainland all the way to the intersection on Siesta Key, right? Now we all know this is language from our brief, but we all know that in fact the traffic is backed up coming north on 41, coming south on 41. It's backed up past Sanderling on Midnight Pass. It's backed up all the way to Ocean Boulevard. We know what it looks like, right? We know what it looks like. And by the way, we have a model of that. We have a mathematical model of that road that we showed to the top guns of FDOT to show the terrible impacts that this will cause to put a light in. FDOT argues that I have no legal standing to contest that the FDOT permit for the new signal and intersection. FDOT's position on legal standing under APA is effectively that the propriety of its actions is immune from third-party challenge and ultimately judicial review. In other words, they're out to lunch, right? In our brief, we argue that this legal argument involves gross error as to the relevant lawyer. My lawyers feel that all the briefing, this is looking forward, this down. My lawyers feel that all briefing in the case will likely be completed by March of 2022. Siesta Promenade, that is Benderson's answer brief, is due on February 14th. So it's moving pretty quickly. After which argument before the appellate court will be in the late spring of 2022. We're ending up, hitting the bottom line. We will be asking the appellate court to agree that FDOT's interpretation of the law on standing is clearly erroneous, and therefore the correct interpretation requires setting aside of FDOT's final order and a remand to the administration court to conduct a formal administrative hearing on the merits of FDOT's intent to permit, right? Right. Finally, we're going to get some merits if we win, okay, before the DOA court. I should add, this is really important. I'm almost done. I'm bored. I should add here that the Siesta Key Chamber of Commerce, who was extremely helpful with me and our legal team and our professional engineer, that when we met with FDOT, Mason Touche of Siesta Key Chamber of Commerce attended all those sessions, and the Siesta Key Chamber of Commerce is really hot now on this problem facing Siesta Key. They're really standing up. They've had enough. Okay, they've had enough, and they're filing a amicus brief. They've requested the court to allow it to submit an amicus brief on behalf of commercial entities and also people on the mainland. This filing is legally excellent. I mean, it's a wipeout. It's really good. And should the court allow this amicus brief to be submitted, the interests of both Siesta Key commercial entities as well as mainland residents will be spelled out in a highly credible fashion. To summarize, finally, the Siesta Key related commercial development madness we are all now facing, in our team's view, is the result of totally irresponsible, and we contend illegal, FDOT permitting action coupled with illegal barrier island land use planning and related BOCC decisions. So if you've got a question or two, Catherine will probably let me get away with it.
I want to say thank
Anybody?
you, Jim. I want to say thank you. Thank you for the effort. Thank you. Thank you for standing up.
We have a shot at winning both of these cases.
I live about a half mile from that proposed development. Why is the construction still going on?
Well, it's very interesting. We will have what's called a side L letter. There's already one filed for that case. What that means is that if we win this case, they have to put everything back the way it was.
What do you think the chances of that are?
Of winning,
No, of getting them to put everything
I
back.
think that by law, they'll have to. They'll be in
If we
good shape.
If we win.
Yeah, if we win. If we win, by law, they'll have to put it back. So every change that they've made on Stickney Point Road to facilitate the intersection with PMC, right, new light and everything, they'll have to put back the way it was. I mean, if you think about what's going to go on if we lose on both of these, like I said, just think about what's going to be coming our way with the construction of this thing, because 3 out of the 4 flows of traffic can get into the Benderson property, but they can't get out without that light. They have to go through the local area, the neighborhood to get out, and that's the only way to do it.
All right, last question. I'm a retired journalist, so just bear with me, okay?
Okay.
Given the political climate, what are your chances? If you were to go to a casino, what would you bet on a casino?
Well, this isn't the only legal matter I'm involved in. I have a major federal case involving climate change. We know what happened in the election. I won't get into my politics, but we know what happened to the election and what's going on. Standing is the nightmare. I mean, to illustrate, the Supreme Court used standing to not take the Texas case on the election. Outrageous. Every lawyer who's just, you ask an independent lawyer, everybody will tell you that was an unbelievable decision on their part. Standing is used, basically, it lets the judges do any damn thing they want in the case, right? But the thing that's good about this is FDOT, I got to be careful what I'm saying here. The arguments they've made are so legally questionable in the citing law that's been cases to argue their case, which have been reversed. It was almost like, I don't think, honest to God, I don't think any of the people I dealt with personally, which included the second highest lawyer in FDOT, I don't think there was any bad faith there at all. I think he wanted, I asked them to treat Siesta Key as a case study. Look, FDOT doesn't even have as a land use area a barrier line.
Yeah.
Think of that. Think of that. They just came up with what they call categories of land use. They came up with a whole new bunch about 2 or 3 years ago, and they don't even treat barrier islands. Now, you could say, well, Siesta Key is the largest barrier island that isn't incorporated, right? And now with the River Road transfer, FDOT doesn't have much to say, but they're stuck with the decision relative to this light because the court also forced them to stay involved with this case. So this is, your question is a really good one. And it's, look at the incorporation, what happened with that. I mean, anybody that went to that incorporation meeting and saw how those Republicans stood up in front of us. For the first time in years, I said to my wife sitting next to me, I'm proud to be an American. And then I saw what the hell happened at the end of that meeting and what those guys said. Basically kiss the ass of the people that didn't vote yet. And even if you convince the right ones so you get a majority vote, expect to lose in a Republican-dominated legislature. Mm-hmm. Good God. I mean, what does it mean? It means that these people are being bought by the developers. If we lose these cases, they'll be, look, the Benderson is already trying to buy out Anderson on the mirror. And if we hadn't done this case, the deal probably would have already been done. You know.
Okay, Jim.
One more, back there.
First of all, thank you so much for what you did. I wrote all the people that I was told to write. I take this as a constructive criticism. It was a hard way to write it. I got some of them back. I copied everything, and if we need a better directions maybe on how to write it.
Yeah, I don't understand, who, I'd like to have
We
better.
We provided sample letters and people to contact.
She's
is what
talking
she said.
about writing to the commissioners.
Writing to
and
the commissioners
legislative
and writing.
Right,
To
it
the
wasn't
representative.
just being my neighbors for having hard
Are you talking, now you're talking about the incorporation
Yeah.
matter?
No,
Yes.
I'm talking about when we were asked to write about the voting for Chris Ziegler, Nancy Dooley, all the.
Oh, okay.
I wrote them all, but some of them came back to me. It was just a weird setup, and so I guess maybe somebody can help simplify directions a little bit better.
Jim, we can do that. We can help that. We need to stop because we do. have
And
one more
it
person
wasn't
to
just
speak.
me, although I'm kind of dumb in that.
Do you have some help for us?
No, I have a question.
Oh, question, okay.
Dr. Wallace, I listened to what you said, I had trouble following it, kind of hard to hear, but did you win the right to argue your case for standing, or did you win standing?
We're arguing the case for standing.
So at the Second District Court of Appeals, the win is that you got the right to make your argument.
On that case, yeah.
Okay,
Yes.
I wasn't sure I was following.
Yeah, okay.
Now, we have one more speaker, so I
One
just
more
want to make
question.
Just
sure.
really quick, what is the county response due on Monday, the 10th? What did you?
It will tell us a lot about how they're reacting.
But they're responding to what?
The
Our
hotel.
brief, our brief,
To your brief?
yeah. It's a response, it's called a response brief, and they'll.
But not the appeal.
No, the
No,
hotel
we're in the county is it's what I call the kill shot case, right? It's the count, it's
But
the
they're
case.
responding to your case. That's what I want to know. The response you're expecting on Monday is the response to the first case. where
Yeah,
there were
they've told the
multiple-
court, that's the date that they told the court, so
All right, thank you.
you're very welcome.